Good morning, everybody. I can still see that counter going up, so I'll just, excuse me. So I will just wait for a few more people to join and then I will start. Can everybody hear me? Can everybody see that first slide okay? Just nod if you can. I'm getting nods, that's good. That's a good start, fabulous. Okay, I'm going to make a start then. There are still people joining, but if obviously this is going to be recorded and you'll be sent the link to the recording at the end. So if you do miss anything, then don't worry too much. You can catch up with it later. So thank you for coming today. So this is a webinar on avoiding disciplinary disasters. My name is Debbie Olver. I'm a HR and employment law consultant with Neat House Partners. I've got 22 years experience in HR and I've worked in a variety of sectors. So I've worked in public, private, charity, not-for-profit, and I've done that in in-house roles, but also as a consultancy role as well. So I'm well versed in the kind of people issues and challenges that are facing your businesses. That said, I always say people can't surprise me and then they go and do something new. So yeah, I'm never going to say that again. You can't surprise me because you actually can. As I said, the webinar today is being recorded, so don't feel that you have to make copious amounts of notes. Just relax and enjoy it. This is your webinar and I want you to get as much out of it as possible in the short time that we have. Obviously, it's quite a vast topic and I could probably talk about it all day long because that's the kind of geeky person that I am, but I won't bore you for that long. Obviously, I'm not going to be able to cover absolutely everything on this topic in one short hour, but I will try to give you a good overview and hopefully answer some questions that you might have. Talking of questions, if I could just ask that they are typed into the chat and I will do my best to either answer them at a relevant point or there will be an opportunity at the end to ask questions. Some of them may be slightly more complicated than I have time to answer today, in which case if you are already an existing Neat House client, then please feel free to contact us and we can talk through specifics with you. Alternatively, if you aren't a Neat House client currently, just let us know and we can let you know what we can do for you. I think that covers that slide. So let me move on to the objectives. So this is an idea of what I'm looking to cover today. Obviously, if you have any questions that take me off on a tangent, we might not get to all of it, but I'm looking to cover these things. So the first thing is that I'm looking to cover good practice when handling misconduct, creating and following a clear disciplinary policy, also giving you a bit of an understanding as to why we need one. Effective communication, in particular when you're having those difficult conversations, and some of the legal pitfalls that we find are quite common with this type of process. So before I get too much into the nitty-gritty of conduct and disciplinary, I just want to kind of look at the differences between conduct and capability. So conduct is where somebody won't do something. So, for example, when you do something wrong. Usually that's an intentional action and the opposite is true for kind of capability where that's something that they can't do. So for all best intentions, they try and they just can't do it. Normally that's unintentional. Obviously there can be very blurred lines and people tend to not fit in the boxes that we want to put them in. So that's a kind of rough idea as to the differences between conduct and capability. Today, we are going to be focusing on the conduct side, but you might need to use your disciplinary process to deal with both those types of scenarios. Can it be resolved informally? It depends what the situation is. There are some circumstances in which it might be appropriate to resolve conduct issues informally, particularly if it is a first or a minor issue. Example here could be somebody is regularly late, or it's the first time of being late. That's quite minor. Maybe they've been late a couple of times. You might just want to have a quick word with them and set that straight. But it is still an issue and can be repeated, and then it becomes a lot bigger. Even if it's going to be looked at informally, a good idea is to investigate the situation. So sit down with the employee, maybe ask them why they're regularly late. It could be something as simple as the bus timetable has changed. They've got caring responsibilities at home that they need to deal with before they come into work. And that could be temporary or permanent. Maybe you can actually come to an arrangement with them. Obviously, I understand that, some of your businesses will be time critical, so you have to be at work at a set time, or else you can't open your shop, or you've got plans and clients that rely on your employee being there at a specific time. So obviously, if they're late, that's quite a big thing. But potentially, is it a case of saying, right, instead of working 9 till 5 because the bus timetable's changed, why don't you work 9:15 till 5:15, or have a slightly shorter lunch break? Those kinds of things. So they would help both you and your employee, because they can be to work on time. You know what to expect from them. You get a full working day out of them, and it's just a simple case of sitting down and having a conversation with them. Check the individual knows the rules. Have you told them that their working hours are 9 till 5, that there isn't any flexibility in that? Have they been made aware of these rules? Have they been there for years and have just slipped and forgotten what the rules are? Could they potentially have a reminder of the rules that will resolve that issue? Have they been made aware that they're only supposed to use the internet in their lunch break? Just reiterate those rules. Make sure that they are fully aware of what the rules are, where they can find that information. Signpost them potentially to your handbook or whatever policy you may have, and make sure. Maybe even ask them to sign to confirm that they've received that information and that they understand it. Check for any previous similar issues. So, for example, the lateness. Are they regularly late? Have you had to have conversations with them several times over the last year, or whatever it might be? Does it seem to be a regularly occurring issue? Even though it's only a minor issue, if it's something that is constantly coming up and being repeated, potentially that needs to be escalated to a more formal process, because it's kind of like a naughty child, isn't it? If you tell them that they have to be here at a certain time and constantly they aren't doing that, then you have to follow through with what you've told them. So you have to show them that there is a consequence to consistently not doing what you've asked them to do. Set some clear expectations for future conduct. So, okay, let's draw a line in the sand. You've been late several times. We've had this conversation. You're aware of your working hours. You've agreed that they are acceptable. Now, going forward, I expect you to be here by 9 o'clock. If you are not going to appear on time, I expect you to call in at least, as soon as you're aware that you're not going to be there on time. Set those expectations so that they know exactly what the success looks like, if you like. So ask them if there's any support they need to achieve that. Sorry, excuse me. And check with them that they are happy that these are clear and reasonable expectations and that they understand what is expected of them. Record all of the above. The amount of times I get somebody come to me and say, "Oh, so and so is late to work all the time. I can't deal with it anymore. You know, that there has to be some sort of consequence to this." Okay, when have they been late? How late were they? How much were they late by? How often does it happen? Oh, all the time. All the right. Okay. So where are your records to show that? Oh, I didn't write it down. It's imperative that you write everything down, whether it's recording it on their HR file or whether it's just making a note of it in your diary, so that you can look back and go, oh yes, it was on that date that they were late, so that you've got that clear record to use for any future actions. We need to be consistent. Let's go back to our lateness example. So we've got somebody who is an absolute superstar, really exceeding at their job. They're going to go far. Not saying we have favorites, because obviously we don't. But if you don't take action against them, but you take action against somebody else who is has the same lateness pattern, you could potentially be opening yourself up to a discrimination claim. So just be careful that you are applying the rules consistently to everybody. Why do we have a policy? The first reason is that it's a legal requirement. So all businesses must have a disciplinary policy that, as a bare minimum, follows the ACAS code of practice. For those of you that don't know, sorry, I'm trying to read the chat at the same time. I'm answering questions without even trying to. So for those of you that might not have heard of ACAS, so ACAS is the Advisory, Conciliation and Arbitration Service, and it is a government-funded body that sets out standards for how employment disputes should be handled and what kind of employees can expect from employers and vice versa. And they provide a low level of kind of free advice for employers and employees in terms of employment disputes, and can get involved later down the line if there are sort of large disputes, particularly employment tribunal claims and things like that, but we're not going to talk about that one in too much detail today. So it is a legal requirement and it must follow the ACAS framework. For those of you who are clients of Neat House and we have prepared your documents for you, your policy will absolutely follow best practice, but also the ACAS code of practice as a framework. A policy sets the standards for what you expect from your employees in terms of their conduct. So it will have things like a list of reasons for gross misconduct. It will have, you know, what the potential outcome could be if they don't follow those standards. I think I'm jumping ahead of my slides, bear with me. So it will set out what they can expect from you, or for what action they can expect you to take if they are suspected of gross misconduct or misconduct at all. It can be used to address issues in the workplace. So it's a really good tool so that you can follow that and be able to address those issues in your workplaces. And it makes the rules clear so that everyone understands them, and there is no grey area, if you like. You know, it is written down. It is clear. We all understand them, and there's no confusion over that. So that's why we have a policy. So there are certain things that need to be included in a disciplinary policy. We've touched on, those of you who've got documents created by our team at Neat House Partners will probably recognise some of these areas. The policy must be in writing. That sounds really logical, but you'd be surprised how many times we come across, oh, it's not written down. Uh, It must be in writing, okay? It needs to give the provision that matters must be dealt with or should be dealt with as swiftly as is reasonable. You'll come across this phrase reasonable quite a lot when looking at employment law. What is reasonable is likely to vary from situation to situation. You know, if it's a massive investigation and massive issues happened, obviously it will be reasonable to deal with it in a slightly longer time frame than, you know, somebody's just been late a few times. It must inform employees what action may be taken. So you will list out in there what potentially could happen if somebody is suspected of misconduct. What the stages are and what the process is, and what the outcomes could be. It clarifies the process and will summarize the levels of management that may be involved. Some people like to name staff in this particular part of the policy. I try to guide away from naming staff either by actual name or by job title. And the reason for that is that if your policy states the managing director will hear the disciplinary hearing, if that person is on holiday for 6 months, you know, off sick, on a sabbatical, what do you do then? It's better to be slightly more vague at this point of your policy, just so that you don't tie yourself up in knots if you get to that point and that person's not available. But essentially, there are three main stages of the disciplinary process. I'll come into them in a bit more detail in a little while. But those three stages are the investigation, the disciplinary hearing, and potentially an appeal. Each of these stages should be heard by someone neutral who has had no involvement in the rest of the process, and ideally a more senior person at each stage. So, for example, if you got your CEO to hear the investigation, who then hears the disciplinary hearing? Okay, so particularly in smaller businesses, you may run out of people quicker. So just bear in mind when you're looking at the investigation stage, who you appoint at that point and who will potentially, it's always a good idea to have in mind who would potentially hear the different stages. And worth just pointing out that this is a thing that Neat House Partners can offer you. So if you do find that you don't have enough people to hear each of the stages, we do have a HR consultancy function, and we can arrange a quote for you to support you in those processes if you don't have sufficient people to hear them. Okay, so that's the process and levels of management. It gives the right of accompaniment to employees. So the right to be accompanied is for an employee to be accompanied either by a workplace colleague or a trade union representative. It does not allow them to be accompanied by their family lawyer, for example. Now, sometimes they might ask for a friend or a family member to be with them. And I think my advice to you is to consider that. So if, let's say you're a small business, there aren't really any workplace colleagues that aren't involved in the situation that they could bring. They might want to bring a friend or family member. As long as that person is not an employment solicitor, I would say you're probably fairly safe to allow them. They have very limited role within the meeting anyway. And actually, if your employee is going through this kind of situation, it's not a nice thing to go through. You do want them to be supported. So, you know, you may allow that. I think if in any doubt, then we can obviously help talk through those situations with you. Yes, sorry, Claire, I've seen your question pop up. Is there any exception to this? Do they have the right if they have a carer, etc.? There may be situations where somebody is asking for somebody alternative as a reasonable adjustment. So it's not a right as such to bring their carer, but if they've got a carer, the chances are they've got a protected characteristic, potentially disability, and it would be reasonable for them to request to bring that person with them. Again, it's not an automatic right, but if we did end up getting to a tribunal, they would look at whether it would have been reasonable for you to have allowed that, and yes, that would be reasonable. Sarah, yes, if so, we haven't dealt with unions previously. Does the employee have a right to bring their union rep? If now, if we're at the investigation stage, it's classed as an informal meeting, so there is no right at the actual investigation meeting to bring anybody at all. But once you get to a hearing, once you get to the kind of point where there is a potential outcome of a disciplinary sanction, then yes, they have the right to bring a union rep. Now, I have varying experiences of union representatives. They can be useful. They know what the situation is. They know what their role is as part of a meeting. And actually, the union rep, whilst they are there as an employee's advocate, because they understand the process probably more than the employee does, they are useful to try and explain the situation to the employee. They would have the right to bring their union rep though at those points. I hope that answers that question. I mean, they might not necessarily have a union rep. Brilliant. Okay, so just trying to pick up my thread. Bear with me a second. I mean, yeah, I think if an employee asks to be accompanied, then by somebody that they don't necessarily have an automatic entitlement to bring, then yeah, absolutely consider it. And if you've got any doubt, then give us a call and we can talk it through with you. Okay, so the policy will ensure that no action is taken unless fully investigated. So it gives a little bit of peace of mind to the employee, as well as providing you with the tools to be able to make fair decisions. And the policy will also provide a right of appeal. And that is always the case when you give a sanction, whether it be a first warning or a final warning or a dismissal. There is always the right of appeal. I will just mention at this point that at the moment, these procedures are only essential if somebody has over 2 years service. Potentially, if somebody has less than 2 years service, you may be able to go through a shorter process. But if there are any protected characteristics that they may have, if there is any chance that they could claim discrimination, I would suggest going through this full process. You may have heard that the government are looking to bring in day one rights. Once that's in, it is likely that the full process will need to be followed, but keep an eye out for our blogs and things on that topic as and when we know more. So let's just have a look at a basic disciplinary process. So first of all, we have considered the informal approach. We've made sure our employees are aware of what's expected of them and all those things we talked about earlier, any kind of support they've needed to be able to achieve the standards that we are looking to achieve. We are getting a little bit annoyed now. This person is still consistently late. There's no real reason for it. They just aren't very good at getting out of bed in the morning. We all have those. If the situation is more serious, or if we've had repeat of the informal approach, then we're going to conduct a full investigation. An investigation process really is trying to find out absolutely what happened so that you can make a decision as to whether a disciplinary is justified. That can take many shapes and forms. For example, if somebody has been caught stealing from the till, there's a CCTV video of that. You can clearly see what they're doing. You may not need an investigation other than to collect that evidence and then proceed to the disciplinary hearing. If it's slightly more grey than that, then potentially you're going to need to conduct slightly more investigations than just getting CCTV evidence. I'm often asked whether you would meet with the employee first or any witnesses first, and the answer is genuinely it will vary depending on what the situation is. For me, it's about having to meet with people as few times as possible, because obviously it is not a nice process to go through, and you don't want to have to keep calling people back in, you know, oh, she said that, he said that, she said that, you know, you want to try to get over everything across in one meeting. So potentially I would sometimes normally even see the witnesses first, so that they can give you an idea of their account of what happened. Then at the next point, I would then call the employee in and talk through with the employee what their response is. And you've got all of the information because you've seen all the witnesses, you've got all of the material evidence that you need, and you have got all of the questions that you're going to need to ask that employee. So there are times at which you might need to go back to the initial witness to just double check something, clarify something. You may need to go back to the employee after you've spoken to a witness to clarify something else. The key really is that you need to speak to as many people as you feel you need to in order for you to get a full picture of the situation and make an informed decision on what action you feel needs to be taken. I'm just going to answer a few questions. So, Market Chambers, do we have the right to know in advance who the employee chooses to bring with them for the disciplinary meeting? Yes, in particular if it's a workplace colleague, because you may need to arrange for that person to have time out from work. If they just say they're bringing a trade union representative, we don't necessarily need to know who that actually is. Sarah, are there specific questions that should be asked in the investigation? I will come on to that just briefly in a minute, but it will depend on exactly what the investigation is for. And David, should the employee have access to the witness statements, as can create more conflict? I will come back to that in a minute as well. Okay, so when I meet with the employee, when I do an investigation, I try to funnel down. So when I invite them to the investigation meeting, you don't have to give exact details as to what the allegations are or what you're investigating. So I've kept it quite vague in the past. So things like we're investigating an irregularity, we're investigating your conduct, we're investigating, you know, you can be more specific. You could say we are investigating unauthorized access of the computer systems or whatever it might be. I quite often don't use the specifics because I want to see the employee's immediate reaction, because quite often that is the most honest reaction. So I will start off by saying, are you aware of the company's policy on IT use? And then funnel down from that. So yes, you are aware of it. So, you know, you're aware that's kept in our handbook. Yes, yep, okay. So you're aware that we are not supposed to access personal internet use other than during your lunch break. You know, just clarify what they're actually aware of. before you get to the point of what they actually allegedly did. Okay. And the questions that you need to ask really are as many as you need to ask. I think of it as a parrot on your shoulder, you know, why, who, what, when, where, how, you know, just keep answering those questions. It's really hard to provide a script. We do try to provide a script sometimes for our clients where you've got an investigation meeting. And I certainly would provide key questions specific to the situation. But because you don't know what the employee is going to say, it's really hard to then do a script for what they might say or might not say, and we could just spend hours writing what ifs. So I think that, you know, for me, the way you've got to look at it is ask as much as you need to, probe as much as you need to, so that you fully understand the situation and you fully understand what their response to that situation is. When you are interviewing witnesses, I would always say that this is being used as part of an investigation process and may be given to the employee as part of an evidence package that they will need to see. So the answer to that is yes, David. They should have access to the witness statements, and the reason for that is that they can't respond to something that they don't know about. You could potentially anonymize those witness statements, but the chances are, if you are in a small team or a small business, it's going to be pretty obvious who made that statement. And the way that I have dealt with this in the past is to, you know, speak to the witness and just to say, look, you know, quite often the thing that they are asked to provide a witness statement for is behavior that is going to impact on them. So, you know, I can't do anything about this behavior unless you tell me what happened. And I know that that's a difficult situation, and I know that that's really awkward. But, you know, actually they do have a kind of implied duty to the company to participate with this sort of investigation so that the company can come to a reasoned outcome. And I think, you know, I don't want to go too much into detail in that. And again, if there are specific situations that you want to talk through with us, then please give us a call. But I do appreciate that that is a difficult situation to be in, and I think it is just about making that employee confident that you will only use that if you absolutely need to. Evolution, can you make reductions if it goes off topic and is not related? Yeah, absolutely. And if the employee asks why you've done that, then I would just use that, you know, it wasn't relevant to the investigation. Hopefully, hopefully they shouldn't go off piste anyway. So I've not really found that come up very often. If I'm trying to think if I've ever come across it, but yeah. So that really is your investigation. Just make sure that you have absolutely dotted all the I's, crossed all the T's, and been able to make an informed decision. Now, just going, this could come either before or during or whatever. Do we suspend? If there are circumstances in which you can suspend someone, but they are quite clear, you can't just suspend willy-nilly. It does need to be for a clear reason and if there is a clear risk to the business. So, for example, you might have a risk that the presence of the employee in the workplace will jeopardize the investigation. So you're worried that maybe they're going to say something or do something that will jeopardize the witnesses' accounts of things. The other is that they pose a threat to the business or its staff. So, for example, if they are caught stealing from the till, obviously you've got the risk that they could do that again. So you might decide to suspend them for that. You could have a situation where there's been physical or verbal inappropriate conduct harassment, bullying, even a safeguarding issue if you work with sort of children or vulnerable adults. And you do have a duty of care to your staff to make sure that they are not at risk. So if somebody is, potentially has been physically or verbally inappropriate, then you might want to consider suspending them. Suspension always has to be with pay. It's not an assumption of guilt, and you shouldn't be used as a punishment either, and only for as long as is needed. So you might start getting partway through the investigation process. You might find that oh, actually this isn't quite as serious as it initially appeared. We're going to bring them back into work. The other thing you could do is consider alternatives to suspension. So for example, if you're a slightly bigger business, or if you have more than one shop or more than one location they could work from, or even home working, you could consider those instead. Restricted access to IT systems. So consider everything that you can to mitigate that risk before you decide that suspension is the last resort. Never suspend on the spot. I know it's very tempting to go, right, that's it, you're suspended, get home. If you ever come across that sort of situation, my advice is to say, I think it would be better if you went home for the rest of the day. We will pay you. We'll be in touch with next steps. So don't just use the word suspension. So I think you need to cool down, take the rest of the day off, come at it from that point of view. Sarah, if the investigation is about the behaviour of a manager, will they also see the statements from the witnesses? Yeah, so if the manager is the employee that you're investigating, then the same rules apply. I understand that can feel pretty uncomfortable, but that's necessary in order for the person to be able to give their response to the evidence that's been collated. Okay. Melody, if the disciplinary matter is related to poor work performance and the employee disputes the fairness or achievability of performance goals, despite other team members having successfully met the same goals, how should this situation be addressed? This potentially is more of a capability process, Melody, which we aren't really going to go into too much detail on today. So I think if you could, I'm not sure whether you are an existing client of Neat House or not, but give us a call, or we'll try and get in touch with you after the webinar to try to give you slightly more specific advice on your situation. No problem. Okay, so suspension. So we've decided whether to suspend or not. We've completed the investigation. We've decided that the situation is going to need a disciplinary hearing. Okay, so the investigating manager is the one that decides whether they feel disciplinary action is needed. So we've got to the end of this, we've decided we think there is a case to answer. Now, we're not prejudging that there will be, but from the investigation, we are thinking there's definitely some sort of misconduct here. We feel this needs to be escalated to the next level. Assuming that that's what's happened, we need to look at the next manager, who hopefully we thought about slightly earlier in the process, so we know who that's going to be. We are then going to forward to that person all of the evidence that we've collated, and they will write to the employee to ask them to come to a disciplinary hearing. There are certain things that the letter to the employee must include, and existing clients of Neat House Partners, just let us know and we will write this letter for you. But these are the things that it must include. So it must include details of the allegations, very specific details of the allegations. So we can't just say the allegation is misconduct. It needs to be the allegation is that you have potentially stolen from the business. This is against our policy, and that sort of thing. But we can help you to write those if needed. And it must contain details of what the potential sanction might be. So if you're thinking, actually, this is gross misconduct and could end in us in a summary dismissal, you need to put that in the letter. If you put that the sanction could be up to summary dismissal, you can then put a lower sanction in place. But if you were to put an outcome of this meeting could be that you're issued a first warning, you can't then up it. So it would need to be, you can increase the you can decrease the sanction, sorry, but you can't increase it. I have had the question before, why would you not just put that it could be up to and including summary dismissal on every letter, and then you're safe? And the reason I give for not doing that is mainly morale. And actually the employee has got a right to know what the potential outcome could be. So I would suggest not putting summary dismissal for every case. The letter must contain all of the relevant documentation, so anything that you are going to use to make your decision must be given to the employee in advance. So witness statements must be given to the employee in advance so that they can see all of the evidence and they can prepare sufficiently for their hearing. If you have not given something to the employee, you cannot use it as evidence. And that's the case, really. Okay. Obviously, your letter's got to include the date, time, and location. That can be on Teams or other video platforms are available, and also who the chair is. I think COVID kind of gave us the in to start using video meetings a lot more, and they are absolutely acceptable. You do not have to have this hearing in person to be able to make a decision. So you need to put the chair's name on, specify that the employee has the right to be accompanied, and give sufficient notice. I always start off as a minimum to say 48 hours. The employee might come back to you and say, that's not sufficient time for me to prepare. Can we make it this date? Especially if they've needed time to arrange a workplace colleague or a trade union representative. They can potentially ask for that to be longer. Again, we come back to this word reasonable. Yes, reasonable probably would be classed as within sort of 5 days of the original hearing date. It is not reasonable for them to keep asking for you to rearrange it because they can't find somebody. You know, you've given them the opportunity. They can't find anybody in that time frame, unfortunately. Then you know you have that opportunity to go ahead. So that's everything that should be in the invite. Then you get to the hearing. I am seeing the questions come in, and I will try and answer some of them shortly, but I'm just going to try and get through this bit first because I think it could answer some of those. So at the actual hearing, there should be a note taker, or you can ask for the employee's permission to record the meeting. So Rachel, that answers your question. Okay, so at the hearing, there should be a note taker asked for their permission to record the meeting. I quite often record the meeting just so that I don't have to scribble down notes and I can actually focus on what they're saying. If they aren't going to give you permission to record, it's good to have a note taker on hand just in case, because then they can scribble all of the responses whilst you can concentrate on asking the questions and listening to the responses. Clarify anything that you're unsure about. So, you know, if something wasn't asked in the investigation and you think, oh, I wonder, you know, about that, then just clarify that. Check again for the employee's response. Make sure that you fully understand as much as you can about the situation, and that you're going to make an informed, you know, be able to make an informed decision from the information that you've got. At any point, I always give the opportunity to adjourn or take some time out. It can be a very emotional situation. So, you know, the employee could ask to adjourn the meeting as many times as they need to sort of collect their thoughts, have a breather, just take time to have a think. But you can do the same. So, you know, especially if you want to look back at your notes and just double check that everything was captured correctly, or that you've asked everything, and just have a think, look back over the evidence, just check there's nothing else you want to ask. And also at the hearing, have things like water on the table if it's in person. Be aware of confidentiality. So if you've got a meeting room where the walls are paper thin and everybody can actually hear what's going on, that's probably not the best place to hold it. And also for the employee to have a dignified exit route. So they don't want to be walking back through an office of people after that kind of meeting. So try to make sure that you're thinking of the location as well as the content of the meeting. Philip, I'm going to come back to your question. With the detail of the allegation, is it enough to put a stakeholder has complained about conduct, or should it detail specifically what the conduct was? The stakeholder may have just said that they were rude, for example, without detailing what was said and done. That's what your investigation stage is for. So the stakeholder, ideally, you would meet with the stakeholder to find out exactly why they were rude, what happened, so that you do have that detail to be able to put into the letter. The more detail goes into that actual disciplinary hearing letter, the better. You wouldn't be going to a disciplinary hearing without having exact details of what happened. If the employee, sorry, Joanna, I'm moving on to if the employee is suspended and sent home, is the re-equipment by law to pay for lost hours? So if the employee is suspended and they remain at home, then yes, the requirement is you continue to pay their salary. You continue to pay them throughout that period. Tracy, if you record, should they receive a copy of the full recording? Not necessarily, but then I would say, why would you not provide that? So I think, if they ask for it, potentially provide it. What I would suggest you do after recording a meeting is to type out the transcript or an overview, and always ask them to sign that to confirm that that was an accurate reflection of what you discussed. Do investigatory and disciplinary notes need to be handwritten? No, not at all. Someone has been accused of bullying. I'm going to come back to that one in the Q&A at the end, if that's all right, because I think that's a slightly different topic, so I want to just make sure we get to the end of this first. Okay. So when considering your sorry, I'm blasting on without putting it on the slide. So then you want to you're at the point where you need to make a decision. Sarah, sorry, if they are typed up, do they need to be signed by both manager and employee? No, not necessarily, and they don't even actually have to be signed. Ideally, they would be signed by both parties, but I take it as sufficient if they've replied to the email to confirm, yes, I've received the notes and I confirm that they are an accurate summary of what we discussed. So as long as you've got an audit trail of where they have agreed to those notes, they don't necessarily have to be a wet signature on them. Okay. So when considering your decision, you need to think about what the potential outcome was given in the letter. As I said, you can give a lesser sanction, but not a higher one. And when making that decision, consider whether the case against the employee has been proved. You don't have to, the test is not as high as if you were in a criminal court. So with employment law, you only have to have reasonable belief that they did something. You don't need to be able to prove beyond all reasonable doubt. So the test is that would the proposed decision be within the range of reasonable responses of a reasonable employer? So if you got to a tribunal, they would be basically saying, would another reasonable employer have made the same decision? Once the decision is made, you can communicate that to the employee. I'm often asked whether to deliver that at the meeting or after it. I think if it's something very serious, I mean, my personal preference is always to adjourn the meeting, end the meeting, and say, look, I want to look back over all of the evidence that I've collated. I want to take time to consider what you've said to me today before I come out with a decision, and I will then write to you, within, the next 48 hours to confirm that decision. If you are very certain about what the decision is that you're going to make, then I would always suggest adjourning the meeting first, telling them that you want to consider all of the evidence that's been put forward, that you've received, everything they've discussed. Give it at least 10 minutes, call them back in, and then deliver your outcome. Don't have the letter with the outcome ready there and then, because that makes your outcome look prejudged. And that's also the reason why I suggest taking an adjournment, is just so that your decision does not look prejudged at all. Okay, so once that decision is made, communicate it, and then give them in that letter they have the right to appeal. Again, if you're a client of Neat House Partners, we can write this letter for you, given the outcome and also the right to appeal. Normally it's 7 days that they have to make an appeal, but you'd need to double check your policy for your timeframes and your specific details. And the appeal is held in a similar way to the hearing. Then they must appeal with grounds for their appeal. That must be stated in the letter. They can't just say, I'm appealing because I don't agree. It has to be something like, I believe the sanction was too harsh for the not the crime, but the behaviour. I think that you didn't take into account this or that or the other, and it could be anything. But they do have to have a reason for their appeal, not just that they don't like your answer. Once you've held the appeal, again, the appeal letter goes out. Exactly the same steps to take as the hearing, with a more senior manager, preferably, and somebody who's not had any involvement in the situation. The appeal decision is the final decision. There's no further recourse through the company. If they still disagree with the decision, potentially their next option is an employment tribunal, but hopefully we won't need to get into that point. Sarah, do you have to give them the decision at the meeting after the adjournment, or can you tell them the decision will be made and you receive the letter within the next days? Yeah, absolutely. And I'm a big advocate for not making a decision on the spot unless it really is a kind of cut and dry situation. So you'll receive the letter within X days is appropriate. Just set that expectation, and that's absolutely fine. It might be that, especially if you're a client of Neat House, that you give us a call and talk through what was actually said at the disciplinary hearing or the appeal, or whatever stage you're at. What do you think? I want to do this. Do you think that's appropriate? And sometimes just bang it off of somebody else that can help you to make that decision. I quite often, I say to my clients, I'm more than happy to be used as a sounding board. Potentially, know the answer. You just want to say it out loud, if you like, don't you? And that's absolutely fine. You can use us for that. That's no problem at all. Are you going to receive handouts for this session? There won't be a handout as such, but it is being recorded and you will be sent the link to the recording. Potentially I can see if I can send you the slides, but I think there's probably more detail in my words than in my slides, but I'm happy to do that if that's something that you would like. Oh, thanks, Sol. You answered the question for me anyway. Okay, so appeal, and now difficult. So just moving on to difficult conversations. So I will just ask actually before we move on, are there any questions about the specific disciplinary process that I've not covered? Natalie, rise of neurodivergence awareness and support. It feels like capability is increasingly more relevant for issues that need to be considered that used to be considered conduct related. Yeah, and I agree. What are likely to be the key differences to be aware of? And I think you're absolutely right. A separate webinar on capability would be a good shout. And Saul, take notes of that, and we can look at that at a future date. I think the key difference is going back to what I said at the beginning about whether they can't do or whether they won't do. With capability and particularly with kind of neurodivergence, potentially you could be looking at a protected characteristic under the Equality Act. So you could be looking to make reasonable adjustments, which could mean kind of getting some sort of occupational health assessment, or just exploring what reasonable adjustments are. for that role. I think a neurodiversity webinar is on the cards as well. So so watch this space for that, because it is, as you say, it's becoming more prevalent and more relevant for these issues. So yes, very point very well made. Let me just motor on with what the content I want to get through is, because I'm wary of time. So I will come back to some of these questions. Now, with difficult conversations, I think that it's all very well me sitting here saying, yes, you need to have this conversation. You need to tell them this isn't right. You shouldn't do that. But obviously, you've got that personal relationship with that employee, and particularly where you've got a small team or a small business, they can be like your extended family. So they are difficult conversations to have, and I do appreciate that. I think my tips on holding difficult conversations are to double check that you're the right person to have that conversation. If you feel too close to the situation, or if there is somebody else that's an alternative that could have that conversation, then you know that might be more appropriate. Prepare for those conversations. So what is it you need to know? You know, and try to have that in your mind before you start going through that that question, that you know, that conversation. Have a suitable venue, remember your question types, remove bias as far as possible, and check understanding of the conversation. I am going to motor on because there are some legal pitfalls that I think are slightly more probably key to this webinar than talking about having difficult conversations. But I did just want to touch on the fact that I do appreciate that they aren't easy to have. So legal pitfalls. These are some of the things that we come across that have caused some difficult outcomes, if you like. Not following your own process is one of them. So if you don't follow your own process, an employment tribunal may award an uplift of 25%. So even if your actual decision was the right one to make, if you didn't follow your process, they may apply an uplift. Not carrying out an investigation. So sometimes it's you think, well, they've just punched so and so over there, right? Disciplinary, into disciplinary. But you didn't do an investigation. You didn't meet with them. You didn't meet with the witnesses. You don't know actually what the background was. So you must do that investigation. Not spelling out the allegations we touched on when I said about writing the letter. So they need to be as specific as possible. If in doubt, give us a shout. Oh, I'm a poet and I didn't know it. Getting the reason for dismissal wrong, putting conduct instead of capability, and those kinds of things. So that can get you into some sticky situations. Ignoring evidence that might point to innocence. So with this, oh, sorry, I didn't try to click there. Sometimes, you know, he punched her and that's the end of it, and that's all I'm going to see. But actually, you know, maybe there was a witness that saw the other person throw a punch first, but you've ignored that because actually this person is maybe you think they're a troublemaker, maybe they've caused some problems before, and you think, right, this is my opportunity to get rid of them. You shouldn't ignore evidence that may point to their innocence or may point to you know, the opposite side of give the employee opportunity to prove their case as well. So it must be a neutral position. Not giving the right to appeal, not giving the right to be accompanied, inconsistent treatment we talked about briefly earlier as well. Poor documentation. If you get to a tribunal and your employee has got diary notes and goodness knows what else, and you've really not got a lot to back up why you made your decision, that can go against you. And reacting emotionally, I think in particular where they are your own business, your business is like your baby, and if somebody's threatening that or has done something against that, then you know it can feel really personal. But we have to be really careful not to react emotionally, and that's the sort of case with that. You know, you're sacked on the spot. Get out. You know, try to put your logical head on and think, right, what did Debbie say at that webinar? Ah, yes, mustn't react emotionally. Okay. So I will now just have a quick look at any questions that I haven't answered. Somebody's been accused of bullying, but before any action investigation takes place, they go off sick. How do you separate out these issues? So this is a really, really common one. I think, if somebody goes off sick, potentially you try to sort of say to them, look, the reason that you're off sick is because there is stress at the workplace. I'm trying to resolve the stress in the workplace. So actually, if you still participate with our investigation, then we can resolve this for you quicker. So we can try that angle. If they are genuinely sick, potentially then you get an occupational health assessment to say, is this person fit to attend a process? And they will say yes or no. So if somebody has only gone off sick to try to avoid a process, they're going to have to face it at some point. And I think that depending on the reason they've gone off sick and whether there's any protected characteristics there, your best thing is to get some advice from preferably us at Neat House. So it will depend on the situation and what they've been accused of and so on. But yeah, that is very common, and we do come across that frequently. Abdul, we have dress code policy in place and have already issued informal warnings. If there is still a breach, shall we proceed with formal disciplinary action? Also, should the team leader be involved, as they were supposed to remind staff but failed to inform management? If this comes back to our kind of formal versus informal conduct, and yes, I think if you have already issued informal warnings, you've already had this discussion many times, and they're still not adhering to what you've asked them to do, then yes, you can then look to proceed with formal disciplinary action. Potentially, if you've already issued informal warnings, that can serve as your investigation, but I would just make sure that there's nobody else or nothing else that you do need to take into account as part of an investigation before proceeding. But you could call that your investigation stage, technically. If the team leader has also, not been enforcing that rule, and you feel that that is an issue for them, absolutely, that could be an informal situation there, or it could be, depending on how serious it is, that could be, failure to report to management, as you say. So yeah, absolutely. Again, each situation is going to be different, so I would probably take advice on that. Tracy, can you combine an investigation and a hearing meeting? No, because you need to fully investigate the situation. You need to go away, collate anything else. You can't just, that would look prejudged. I think is the answer to that question. So no, I would recommend having a gap between the investigation and the hearing meeting. If the employee has a mental problem that he is involved during the informal meeting, the employee still keeps being absent from work as this is affecting company performance and the evidence. Yeah, we're on that blurred line between conduct and capability here, but also, if somebody's got a mental health issue that potentially is covered by the Equality Act and as a disability, and I think that we are going into too much detail in that, really, Joanna. So if you could potentially contact us afterwards, we can go into the exact situation in a bit more detail, if that's all right, because we are just sort of slightly running over now. I want to make this the last question, if possible, just from actually I will try and cover Sarah's. So if you feel that you need to leave, then absolutely feel free to go on and leave. I will just cover these last couple of questions. But as we've said, the recording will come to you anyway. So if you do miss anything, then you can refer back to it. Member of staff regularly late, says she has ADHD. Oc Health said although she hasn't been diagnosed, it looks like she has time blindness and she continues to be late. And I think that situation is a case of asking occupational health what reasonable adjustments we need to put into place. Ultimately, You can still discipline somebody for that regular lateness, because if it's something that is business critical, you know, you need to open a shop on time, you have patients or appointments that must be adhered to at those specific times, then it doesn't matter the reason for that lateness. The fact is that person can't continue in that way, and it's business critical. So um, we've already moved her start time back 15 minutes, and now she's late for that start time. Okay. I think that this one is potentially one that we can look into. Okay. uh, I think that one does need a little bit more investigation, so it would be better to have a private conversation with you about that, Sarah. But it's about reasonable adjustments. If you've put those reasonable adjustments in, which it sounds like you have, and now she's still continuing to be late, then you can take formal action potentially. I don't know the full situation, but yeah. Claire, yes, you can continue to investigate while somebody is off sick. Rashmi, I think I'm out of time here. Saul's just put a kind of polite reminder in to say that we've come to the end of the webinar. I think I've covered everything except for Rashmi's there. So if you want to give us a call to discuss any further. Sorry if I've not got to your question. I just want to end by saying thank you for your time. This is the telephone number on the screen that you can call. I think Saul's put it in the question and answer chat anyway. There's also our website that you can go to. We do have some information available on there. But if in doubt, give us a call. Whether you're a client or not, we can try and work something out that we can work with you and try to provide some advice for you. So I hope you've all found this useful, and we will stay in touch with details of future webinars. But it's been really lovely. So thank you so much for your time. Take care, everyone.